Let's take a look at affirmative action. Statistical data comparing an employer's workforce to the available workforce in the labor market is also important for purposes of affirmative action. Affirmative action has been defined as those actions appropriate to overcome the effects of past or present practices, policies, or other barriers to equal employment opportunity. Careful recruitment aimed at diversifying a company's workforce and eliminating unnecessary obstacles to employment is an important part of affirmative action. The particular focus of an affirmative action is improving the employment opportunities of groups that historically have been victims of discrimination: women, minorities, disabled persons, and certain veterans. For most employers, the decision to adopt an affirmative action plan is voluntary. However, affirmative action is required of most companies that have contracts to sell goods or services to the federal government as well as many states. Companies that do business with the federal government must comply with Executive Order 11246. This executive order requires companies with contracts worth at least $10,000 to have a non-discrimination clause in their contracts. The non-discrimination clause requires contractors to do more than simply refrain from discrimination. They must take affirmative action to promote equal employment opportunity. Under Executive Order 11246, contractors and subcontractors that have at least 50 employees and contracts worth at least $50,000 must develop written affirmative action plans. Contractors have parallel requirements for qualified individuals with disabilities under the Rehabilitation Act of 1973 and for military veterans under the Vietnam-era Veterans Readjustment Assistance Act of 1974. Compliance with Executive Order 11246 and these other laws requiring affirmative action by contractors is monitored by the Office of Federal Contract Compliance Programs, OFCCP. Besides government contracting, the only other time when employers are required to engage in affirmative action is when a discrimination suit results in a settlement or court order that includes affirmative action as a remedy. Affirmative action that arises out of legal proceedings can be imposed as a remedy following a court determination that an employer has had a pattern of discrimination or as part of a judicially approved settlement between the parties. The rationale for and scope of an employer's affirmative action program must be set out in a written document known as an affirmative action plan. Affirmative action plans must contain three basic elements: a reasonable self-assessment and analysis, a reasonable basis for concluding that action is appropriate, and reasonable actions.